As I promised, the parties, I'm keeping track of the time, because we will reach a conclusion at the end of today, and I do need the last 15 minutes. And so these motions were both filed by Ms. Cheney. The time talking about them is going to count towards her allocation time. So the first motion is a motion to dismiss expedited ruling requested. And Mr. Gordon, I'm not sure if you received it. It was filed on October 25th.
Does it have to do with motion to dismiss claim of fraud or something like that?
Yes.
I did receive that, and yesterday I e-filed a response to that.
Mr. Gordon, I'm sorry, I have not received your response. Our clerk's office is not maybe that quick in being able to get it processed in time to get it to me.
I should have emailed it to your citizen.
You can tell me the substance of your argument.
I will, Your Honor. I was a little unclear of the substance of the defendant's motion, but it sounds like, if I remember correctly, it's a motion to dismiss claim of fraud or for fraud, claim for fraud. And I guess my first point was that their plaintiff's complaint has no count of fraud against the defendant. After reading it, I think what the defendant is saying is they're asking to dismiss the plaintiff's case based on an allegation of fraud, and as I pointed out in our response, they make arguments and attach a bunch of unauthenticated documents. It's kind of tantamount to filing a motion for a summary judgment in the middle of trial. I think it's improper, Your Honor. The defendant certainly will have time today to ask questions and present evidence, and for those reasons, Your Honor, we think that the motion should be denied.
Ms. Cheney, I want to hear from you, but I want to hear from you on two topics. And then you have things you want to tell me related to this motion we do so. First topic is the procedural ground with which you filed this motion to dismiss. You cite Rule 41B of the Arizona Rules of Civil Procedure. We are in the Rules of Procedure for Eviction Action. Rule 1 says that the Arizona Rules of Civil Procedure apply only when incorporated by reference into these rules. And it has a couple of exceptions for 42.1 and 42.2. So I need to know under what legal ground you are filing under the rules of Arizona Civil Procedure into an eviction law.
The Arizona Civil Procedures don't cover eviction lawsuits?
True.
And I was mistaken, but isn't there something in eviction law where you can't lie on the stand in multiple hearings? You can't.
If you're asking about if there's kind of perjury for lying under oath, I will just remind you that an eviction action itself is very limited in scope. It's unlike other kinds of lawsuits, right? And in the rules we discussed that. These eviction actions deal only with possession. As we discussed in our last hearing, there's a restriction even on counterclaims that you're allowed to do in an eviction.
I didn't know that there was any anything that would bar you from putting in a normal dismiss motion under 41B. That 41B does not apply to evictions?
41B does not apply to evictions unless there's some kind of legal allowance that I'm not seeing within the rules. So that was one thing I wanted to address. But to answer your question, you still have the opportunity for impeachment that you have in cross-examination. Believe that a witness is not telling the truth. You have an opportunity to ask them questions to demonstrate the lack of truth telling. Does that make sense?
Yeah.
So there's not a countersuit that you do for perjury within an eviction, but you can show by impeachment.
Like, is there anything in the eviction code that you know of that would allow me to file a motion like this?
So one, I can't give you legal advice. There is a rule book out by the elevators in our small law library that you can look at and look at the rule for eviction action. So, if the substance is, you're asking for the case to be dismissed because you believe that the plaintiff has, lied on the stand.
Well, and used abuse of process to bring an eviction claim, knowing that there is an agreement on the property.
So abuse of process, that's a separate legal claim that doesn't belong in an eviction. Abuse of process is a separate legal claim.
I understand what you're saying, I'm just not.
But it's not part of an eviction. So to clarify, the eviction isn't by title lawsuit. The eviction isn't a lawsuit for unjust enrichment. It is a very narrow scope compared to other civil litigation. We're only dealing with possession of the house.
Understood.
Okay. So, before I get further, Mr. Gordon, do you need to clarify any of your positions, or are you fine? Okay. So, Ms. Kinney, what I'm hearing from you is that the source of your motion is that you believe this action should be dismissed because you believe it has lied on the stand. Is that correct?
Yes, she lied on the stand and she brought this suit based on misrepresentation.
Okay. Your motion to dismiss then is denied.
That was a correction on the date.
So the second one, I don't understand what it is. Let me, so for the record, because it's all being recorded, what it says is notice of filing defendant's motion to dismiss 10/25/21 correction. So what does this notice of filing mean?
The notice of filing was, I put in I had the wrong date. I said that she lied in October 10th on the motion, and it was October 20th, but I didn't see it. So that's what that filing was about.
I think that's something we normally call a notice of errata, where you point out an error that you've made. So you're saying that this notice of filing was saying that you're correcting a error that is in your motion.
Correct.
Okay. There's nothing that we need to do in this.
No. Okay.
Have you filed any additional motions that I need to address?
No.
Okay. All right, we need to, Mr. Gordon, anything else before we begin the presentation?
Just briefly, Your Honor, there were some additional exhibits that were filed apparently late last week. I got my copy the day before yesterday. But in looking over those, my recollection is the last hearing, the defendant said she would go ahead and file additional exhibits to include the exhibits that were attached to her answer in the justice court. And in looking through those, there were 4 exhibits that were not previously listed in the justice court pleadings and were not previously disclosed. And given they were closed to me the day before yesterday, we would object to the admission of those exhibits.
So, Mr. Gordon, can you identify which exhibit numbers using the court exhibit sheet?
Yes.
I know which ones we're talking about.
So the exhibits that I went and compared the answer and counterclaim to the exhibits that were filed earlier this weekend. Exhibit 53, Exhibit 55, Exhibit 56, and Exhibit 57. I did not see that those were previously attached to the answer and counterclaim. So I believe they weren't disclosed in a timely manner and should be.
And right now, you haven't been offered, and unless you're looking to stipulate the admission of the other ones, my intention is to deal with your objections to these specific ones given my name.
Can I say something?
Go ahead.
When I was asking you about filing exhibits, it was not limited just to what happened at the justice court. I asked if I could file, or where they were, and you said, oh, well, if you want to get exhibits in, you need to get them in right away because of the 5-day thing, and they were put in with the 5, within the 5 days before trial, like you said they needed to be.
So, Ms. Keeney, what I just told Mr. Morton is that we're not addressing whether, until you actually offer them, and you might find that you don't need to offer some of them, depending on how your witness testimony goes. So, we're going to take them up as they come. All right, I'm reminding first the parties of the rule of exclusion of witnesses, so if there's any witnesses here in the courtroom, that aren't a party, they do need to leave. I believe where we were in the presentation of evidence is that Mr. Gordon's client had been on the stand, we were getting ready for cross-examination. I misstated that. Okay, so the first thing we need to do, Mr. Reed, we need to put you under oath again, so you'll come up here, maybe let's show you where.
You solemnly swear or affirm upon penalty of perjury, the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
I do.
All right, Ms. Cheney, now's your opportunity to cross-examine this witness.
I want to enter or, use an exhibit, I think, correct?
To use the exhibit, there's a formal process you go through where you have to first lay foundation.
Okay. Roxer, do you remember us speaking about the June 13th email? When you were on the stand?
Specifically, what about that? Or June 13th, I know there was an email June 13th, yes.
Yes, that email. Can I then bring that into, or ask for?
So let me ask you, the exhibit you're referring to, was it admitted already?
Yes.
Then there's no problem. All you do is you ask for my bailiff to present a certain number of exhibits to the witness.
Can I have can you present exhibit 13, court 26 to the witness, please?
So I will say 26 is not admitted. You should have this sheet updated from the clerk's office in front of you.
Okay.
And on that document, it tells you which of our exhibits have already been admitted, and you see that exhibit 15 has been admitted, exhibit 19.
Well, those are his, so how do I get one of mine admitted?
So if it has the same information, you can use his exhibit.
It's not got the same information.
So if you want to admit your own exhibit,
Yes.
then you have a process for doing that. And the first thing is you have to have this witness lay foundation. So the witness would have to testify regarding generally what the document is, if you recognize it, if you altered it.
I'd like to show it to her so that she can identify it.
And she'll also do all of that. At that point, it's still not admitted into evidence.
Okay.
So you first have to put foundation regarding what the document is, when it happened, without testifying into the details. Once you have foundation completed, that's when you offer it, you listen to Mr. Gordon to see if he has any objections, and if not, then you submit. If there are objections, then you deal with it.
Okay, so you remember the June 13th email?
I sent you several, I believe, in June, no more than one, so I'm not sure what it contains.
Pardon me a moment. Ms. Cheney, we can ask my bailiff to show exhibit 26 to this witness and allow her to review it before then you start asking her if she recognizes it.
Oh, okay. Could you please present her exhibit 26? Recognize this email that you wrote?
Yeah.
And you're talking about a rental agreement and some other things in there, correct? And questions about cost, and not trading.
Hold on, you can't testify to the content of it. If you want this exhibit admitted into evidence, it goes through the process we described, which is what is it, was it over, has it been altered, the true and accurate representation of the email.
Is this a true and accurate representation of the email that you sent to me on June 13th?
I see that there is an email, yes. From me, that's accurate, appears to be.
Okay. And now can I move to admit it into evidence?
Yes, I mean, you can offer it as evidence at any time, so are you offering it now?
Yes.
Mr. Gordon, any objection?
No objection.
All right. Exhibit 26 is admitted without objection.
And can you look down at the bottom of the page and read, my response to your proposed agreement? It's underlined.
May I say that this is a draft that I never received?
Yes, you may say that this is a draft you haven't received, but still, can you read my response to what you wrote on June 13th, the first time that, and can you read the underlined section, please?
We had a deal you ran, no need to renegotiate a price next year. I didn't receive that.
No, you didn't, it's a draft. And can you go to the third page? And read your next email? That short paragraph there, and starting your reading this over?
In reading this over, I don't think I am clear about some points. I'm really looking forward to seeing all the improvements that you will make to the house. Your vision and creativity will make it a beautiful home, and I want you to reap all the benefits from that. I'm not sure how to do that. So I was thinking that we come up with a price that is fair to us and pays you for the improvements. You would be purchasing it without me getting money for the improvements you make at a price value that was set before the improvements were made. That's why I mentioned Ms. Green's estimate. That did not take into account anything you are doing. He has not seen anything you've done and takes into account the future improvements. Excuse me.
The next lines as well, please.
Please know I'm trying to respect and love you while dealing with our business and backgrounds. Please take this in the spirit of love. You are appreciated.
When you were testifying last year, did you say that you never asked me to make any improvements? Is that accurate?
I think she said, we testified last year?
Last time we were here, sorry.
I thought I heard that the same way.
I'm sorry.
So is your objection?
My objection is, yeah, I'll probably respond to that.
Do you recall testifying that you never asked me to make improvements?
I recall testifying that I never asked you to make improvements. Yes, I guess if that's what.
And what about the bathroom? Did you ask me to improve that?
That was before I got married, before this was before. I was talking about after that.
Do you recall calling me and telling me that Paul was forcing me to sell the house?
I recall a conversation where we talked about that, and that I said we agreed. Paul and I wanted to sell the house.
And what was my response when you told me that?
I don't understand the point of this.
Oh, the different issues is for a lifetime.
Right, so please repeat your question.
What was my response when you told me that Paul was selling the house, or that Paul was forcing me to sell the house?
Well, I remember that there were several conversations, so what I recall is that I told you I was getting married and selling the house.
That's not what I.
Oh, hold on a second. You asked the question and she's answering it, you need to let her and not talk over her. You don't have a court reporter, or that court reporter was yelling at us right now, and so my job is to make sure that we keep a clean record.
Okay, so what I recall is that we had a conversation, and in that conversation, I told you that I was getting married and selling the house. Paul and I both agreed that we were selling the house, and you asked for an opportunity to purchase it, and I said that I would try, that we could try to see about getting an agreement. It was a conversation.
We're referring to two different things.
Please make sure to speak into the microphone, and you can move the microphone closer if you need to.
What did I do in your house? What did you contract me to do in your house?
I didn't contract you to do anything. There was no written contract, no agreement on anything. I didn't know. That's my truth.
So are you alleging that for free I remodeled your house?
I don't know that any remodeling was complete.
Did you get heated floor, custom walls?
Way before we decided to sell the house. And
Did you ever pay for the services provided?
Did I ever get an invoice, or did I ask for them?
Did you ever pay for the services provided?
I didn't get an invoice, Becca. I didn't know if you were doing it.
Hold on. You would need to answer the questions that she's asked. Your attorney will give you an opportunity to clarify those questions if he deems appropriate in reading that.
Okay. So,
Did I ever agree to renting the house?
you agreed to pay for some of it, for the bills, and it is my understanding, can I finish? Yes. It's my understanding that rent is a
Objection,
generous.
non-responsive.
Can I finish the sentence, please?
Can you ask your question again?
I don't even know what my question is. Did I ever agree to the house being a rental? Yes or no?
It depends on how you interpret rental.
Yes or no? Did I ever pay monthly?
Yes.
I would like to, have, an exhibit, if I could, is number 20, please.
But it's of course exhibit 20, and that's the number that we use.
Oh, I'm sorry, I don't,
We need to take moments to renumber yours on your sheet that matches.
Chance I could get some water.
do you see what that is?
Mm-hmm.
And that's check dated August 29th.
Mm-hmm.
I'm sorry, you can please respond yes or
Yeah.
no, please.
I'd like to have that exhibit, moved into evidence.
This is court exhibit 33, is that
Correct.
Mr. Gordon, any objections?
No objection, Your Honor.
Then exhibit 33 is admitted without objection.
Is that a monthly payment or is that a multiple block of payments?
Well, this is the payment which we requested and included a payment for the month previous and for the current month.
And, in one of your demands, you wanted $1,700 a month. Did I ever pay $1,700 a month?
You paid,
Yes or no?
did you ever pay $1,700? I don't know, probably not. Because you,
Nothing, because nothing.
well, can I
There's
explain?
another question.
Okay.
Do you recall the notice that you were sent in response to your notice that was posted on my door about, the termination of tenancy?
Yes.
Can I have exhibit, sorry about that, exhibit 44, please. Yes.
This is to it. Okay. Got it in front of me?
Do you recall getting that notice
Mm-hmm.
in email and also in sent form?
Yeah.
And what is the content of that saying? Just as a general, you can generalize.
So let's see.
Specifically about whether we had an agreement for the house or not.
So she can't testify as to the contents of this exhibit, she can just generally say, you know, the exhibit is an email, or the exhibit is a chat, or things like that, until it gets admitted into evidence.
Oh, I need to admit this, please.
Exhibit 44, Mr. Gordon, do you have any objections?
For foundation, Your Honor, I don't think there's a foundation that's been made.
Or objections? So you need to lay foundation for this exhibit.
Can you give a broad brushstroke of what, how do I lay a foundation without? Does that bring up a contract in it? An agreement for the house?
So you're right now asking her to testify to the contents of the exhibit. So foundation, I know.
Okay, I think I got it.
Okay.
That was in a response to the notice that you posted, correct? For termination of tenancy.
I received it after that was posted.
Yeah. And why did you receive it? What was the reasoning for me sending it to you? We've talked about it on several phone calls and.
What you're saying, it says, Ray, you're continued breach of agreement. That's what it says.
Correct. Can I admit it into evidence?
You can ask, but Mr. Gordon has an opportunity to object. Are you asking for David and that?
Yes, based on,
No objection, Your Honor.
Exhibit 44 is in.
and, in that email, does how, do you recall telling me that I couldn't pay bills anymore? And was there any problem with payments for me?
Yes?
After your initial call, telling me that Paul was selling the house, you made another call to me a few days later, and it started out with saying, now that I can finally make the past right, here's what I'm gonna do. What did you propose?
Objection, Your Honor. States facts that aren't in evidence. My client has never testified that she said that. I don't think there's any evidence for them that she made those statements.
Your attention.
When you called me following the call after that. Do you recall making any agreement with me for the house? No. Then why did I not leave?
I don't know why you didn't leave. You're asking me to read your mind, I don't know.
Well, we have had a lot of discussions about this. How many discussions do you think we had about the purchase of the house?
What I can give you a number about is something different. I
That's
don't
not
know
what
how
I'm
many
asking.
discussions we've had about the house.
Would you say numerous discussions?
I tried to keep everything in writing, so I don't think that there was not that many conversations in person or face to face. Anything that was of significance was written. To the best of my knowledge, I mean, I'm
And
sure
in
there
the
were
June 13th email, that was the first one that you sent me, correct? About the house?
No, actually, I believe there was one. So we talked in January, in February. Then in March, I sent you an email about the house. So it was consistently, and
No,
I counted. Yeah.
Hold on a second. Are you trying to make an objection? Because how you do that is you say objection rather than just interjecting. That makes sense? So are you trying to object to this witness? Her testimony?
Yes, because it's non-responsive to the question that I asked.
Some of the question was she didn't think, or the answer was she didn't think that this was the first time. And then she was going on an explanation. So you're
To a different time. She was talking about a different time that, okay, I'm sorry. In the second section of the email that you read earlier, from June 13th,
I don't have that in front of me anymore, but
I'm just terrible at this. So you were saying that we didn't have an agreement on the house, correct?
yeah.
Okay. Can, can I introduce, an exhibit for her to see?
We can show the witness the exhibit.
Okay, can you show the witness exhibit number 1, please? One. Yes.
I'm sure she's not gonna come back. So that's okay.
Is that your phone number? Does that call log show your phone number, calling mine?
I don't know, I don't see that this has anything about my phone number. It has a bunch of numbers on it, but
Well, you don't know your own phone number?
where is it on the document?
It is. Don't see your phone number on that call. It should be a single highlighted line, and
No,
there's no single highlighted line,
there is.
and that's not your phone number calling my phone number for 42 minutes?
I don't see anywhere on here, I do not see my phone number on this document anywhere.
Oh, I'm sorry. It says January 29th, and it's my phone number that would be on that one, on the single highlight. But if you look at the next page, it says January 29th, and that is your phone number
Yes,
as an incoming call.
okay.
So that is that call. Do you recall what we discussed?
I'm going to assume that that is the conversation where we discussed your possibility of buying the house.
Okay. And, can you show her number 2, please? Can I have this into evidence, please?
I'll object to foundation, Your Honor.
So I need you, Ms. Cheney, to first argue, so I agree with Mr. Gordon, there's not enough foundation. And it may be impossible to get from this witness, because this witness is not the one who cleaned off the call log. So do you believe that you have a way of having this witness testify that the call log actually looks like this? Or is that something you're going to have to testify?
Either or. I'm just trying to get to the notes that, came from that call. So that was kind of foundation for number 2. But you do recall us speaking, correct?
Yeah,
Okay.
So, Ms. Cheney, hold on, we haven't gone through yet the admission of Exhibit 1. The issue that we have is I don't think this witness is going to be able to testify that she's the one who sent off the call
Okay.
log, that is an accurate
So
representation.
I don't move to admit it then, at this time.
It's been objected to, it is currently not admitted, which doesn't mean that you can't try to admit it during your own presentation.
Excellent. Okay, great. Well, since you brought up the agreement, that's laid foundation for Exhibit 2, correct?
That's what it would.
Oh, I'm sorry, can you show her Exhibit 2, please? Do you recognize the information contained on there? No, I don't. Okay. So if you read on the right-hand side, under Mom Wants,
Testify as to the document. If she did not create this document,
Okay.
chances are she doesn't have
Okay.
the foundation for its introduction.
Okay, well, I guess that I can't admit that either then, at this time, correct?
I doubt that you'll be able to lay proper foundation for it.
Okay,
You
I
and
understand.
you're the one testifying.
I understand. Thank you. I'm sorry. What was your reaction when you found out that Caroline was going to testify? What did you do?
Objection, Your Honor, relevance, and then she's asking about a reaction to a witness who's not here to testify today. How that's relevant to the issue of possession of the house.
Ms. Kinney, I want you to address the relevant issue in the objection that Mr. Gordon. How is it relevant whether you have possession of the house or not?
Because Caroline is aware of the agreement. And if there's an agreement on the house, then she's not entitled to possession.
But you're asking about her reaction to a witness.
Understood.
And so I'm struggling to understand the relevancy of your reaction.
Because she called or got a hold of her, found out that she was going to testify, and then moved to have her not testify, even though she's her stepdaughter, based on what she was going to testify on.
Sure, the objection is sustained.
Going back to the,
I just want to note for the party's record, Ms. Kinney has used slightly more of the time, other than that, you're fairly equal in time allotted. I just want to make sure the parties are properly accounting for this. So, Ms. Kinney, I think you have yourself as a witness and someone else as a witness, more cross-examination. I just don't want you to blow through your time in cross-examination.
understood, okay. And I don't think I have anything further. Can I recall her if I need to, if I have time at the end?
So you can call her as your own witness during your presentation of evidence, if you've got the time.
Okay.
All right, Mr. Gordon.
Follow up from questions you were asked. You were asked a question about whether you ever contracted with the defendant for work that was done in the house. I just wanted to clear that up. Did you ever enter any type of agreement with the defendant to work inside the house?
Rebecca did some work for me.
And did Rebecca ever ask you to pay her for that work?
There was a question as to whether that was in lieu of rent, and she did ask for reimbursement of, she submitted me a list of things that she spent money on, and I paid her for that. I'm not answering your question, rephrase it, I'll try again.
Well, and I guess the question I want to know is that at some point, did Rebecca ever give you an invoice that itemized what she felt she was owed for the work that she did? Did you ever ask her to provide something like that?
Yes. And I asked her to provide that before the work was done.
There was a check that was shown here earlier, I believe it was Exhibit 33, as I recall. It was a check that Rebecca wrote to you. Do you recall the exhibit I'm talking about?
Yes.
Okay. And there was a question, or I think you were attempting to answer. I just wanted to give you a chance to clarify this. I believe earlier testimony or emails that were offered in this case indicated that the mortgage payment on the property was approximately $1,700 a month. Is that right?
I've been paying $1,000, I think it's, 800 something, yeah.
So the $1,700 figure, does that include more than the mortgage?
Yeah, it was a mortgage and the bills. I figured out what it was costing us her to be in the house, asking her to pay us the cost of those bills.
And she wrote you a check for $3,200, correct?
What, 36, something, 30,
It
it was over $3,000. It was 2 months.
Okay, and so for clarification, I believe you testified that you didn't know whether or not she had ever sent you a check for $1,700. Can you explain why those amounts might be different?
Well, we asked for was $1,700 a month payable on the 10th, and that included all the bills. And then Becca went ahead and switched some of the bills into her name. So she paid some of the bills, which means we had to deduct that from the $1,700. So in effect, she was paying the $1,700, but some of that money was going to a utility company perhaps, and some of it was coming to us because what we had proposed is that we pay the taxes, the mortgage, the homeowner's insurance, those which come to me. That was what we set out, and then it got changed by Becca going ahead and making payments.
All right, really quickly, I did want to ask you about, there's a counterclaim that's been made in this case with regards to the Arizona Residential Landlord Tenant Act. Got a copy of that in front of me. I'm not going to go through the whole thing, but I did want to ask, just for clarity from you, at any time while Rebecca's been living in the property, did she ever send you some type of written notice that stated that something was broken in the property and demanded you fix it?
Very early on, when she was staying at the house before the furnace went out, and so we worked together to get that fixed. Other than that, I didn't receive any notice that anything else was wrong with the property.
So you're
Nothing, no request to fix anything.
Okay. Just briefly, I'm going to read there's a paragraph 2 in the counterclaim, and it references that you're holding in excess of $45,400 plus the defendant's half of Al Furman's disability back pay. Do you know what that's referring to?
45, I don't know.
Do you know what Al Furman's disability back pay is referencing?
Yes.
Tell me what that is.
It was a claim that to the government on his suffering from Agent Orange exposure.
Well, let me ask you, who is Al Furman?
Al Furman is my late husband.
And was there some type of disability back pay settlement that Al Furman received?
So there was a settlement, yes.
And does that, when approximately was that money been received?
That was a year before I met Paul. It was January of 2019.
And is there any relation whatsoever to Al Furman's disability back pay and Rebecca's occupancy of the house?
No.
Do you have any personal property that's in the house right now?
Yes, I do.
And have you made attempts to get some of that personal property from the house?
Yes.
Was it successful in getting that property out?
No.
Why not?
I would make a request to come and go through things and was told no. Repeated request to go through the things in the garage and not allowed to. I had to write a list of the things that I remembered in my house that I wanted. I wasn't allowed to go in my bedroom, my closet, the garage, the other bedrooms, my bathroom. I wasn't allowed to go through and clear my things out.
All right, let me ask you, you've taken the step of filing an eviction lawsuit against your daughter, correct?
Yes,
Okay, why are you asking the court to remove Rebecca from the
because she said that that was the only way that she would leave.
Um,
I want to sell the house. I want to get on with my life. I don't want to continue to deal with it.
is there anything else that you'd like the judge to know in this case?
There were, if you look at this from when it started in I will say January with that phone call in 2020, I made a mistake. Trying to do a nice thing. And I spent hours on proposals and trying to make it work so that it would be a fair deal for her to stay there and inheritance to my other children. And it wasn't, so that's 2020. In March of 2021, I counted that there were at least 21 times that I asked for her feedback. What were her thoughts? What were her plans? And it wasn't until March that she gave me this, what she says is an agreement for 2020 for the sale of the house. Her agreement, she said, this is not my recollection of the agreement. It is the agreement we made in 2020. Now, why, dear God, why did she wait? How many months is that? 13, 14 months after asking for her feedback. Why did she wait that long? Why did she get proposal after proposal and not say, well, you know what? We had an agreement. Let's start there. Instead, you want to email, I want to see your plan. Tell me what your thoughts are. We can use that as a starting point. And we can come up to some kind of agreement. In the meantime,
Yeah.
okay, I'm rambling, I'll shut up.
Just in conclusion,
Yeah.
in your testimony, there was never any agreement reached with Rebecca regarding her purchase.
There were conversations, but there was never any agreement reached, no.
Okay, no further questions.
Thank you.
We call Paul Scott as our next one. Yes.
Do you solemnly swear or affirm upon the penalty of perjury, the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You listed off Mr. Boyd on it.
Thank you, Your Honor. Mr. Scott, would you begin by stating your full name for the record?
Paul Scott,
And what's your relationship to Roxanne Scott?
her husband.
How long have you been married?
We've been married since February 15th, 2020.
Very briefly, could you describe your educational background and work experience?
I have bachelor's degrees, and I have degrees from Duke University and University of Arizona, culminating in a PhD. My work experience, I worked for 3 different aerospace firms over a space of up until 16.
Have you had any involvement in discussions between your wife and her daughter with regard to, the house that's at issue in this case?
Yes.
And can you describe generally what that involvement has been?
Since we actually first were introduced, up through all the time, the relevant time, we've been in constant communication. And we discussed, possibilities, where we were gonna live, and so forth, and and the situation with the house, among other things. And
Sorry, let me stop you there for just a second. Do you know if Roxanne or Rebecca had specific discussions about Rebecca buying the house?
yes.
And how do you know that?
But,
How do you know that?
I heard at least one of those, and of course, I've seen, many communications, emails, et cetera, about that possible transaction.
And have you had conversations with your wife regarding Rebecca's possible purchase of the house?
Yes.
In all these experiences covered, are you aware of any agreement that was ever reached between Roxanne or Rebecca for the purchase of the house?
No, and I believe I would have been the first to know.
Do you know if Rebecca ever claimed that she was owed money for improvements that she made to the house?
Yes.
Do you know if she ever asked her mom to pay for those improvements?
Yes.
Did you know if Rebecca ever provided her mom with any type of invoice or breakdown that would give a number of what she was seeking for those improvements?
No, not to my knowledge.
No further questions.
Did you cross examine, please?
Paul. Planned and coordinated your wedding.
Excuse me?
Who planned and coordinated your wedding?
You did?
And who packed up the house for Mom when you guys had the movers come while you were traveling?
You did?
Have I kept my word to you consistently?
I don't know if there's an instance when you've given your word to me.
Well, I said I would plan the wedding and.
Yes.
Okay. And do you recall calling and singing happy birthday to me in March when you guys were traveling?
Objection on relevance.
So we're specifically talking about the possession of the house.
Understood.
So tenancy versus ownership, birthday call, we're not thinking about.
The birthday gift is,
Maybe get the birthday gift portion.
okay. Do you recall the gift that Mom gave me on that call?
Don't recall that.
Do you remember her saying things and me writing it down and then reading it back to you guys?
No.
So you don't recall anything about her giving me a gift on my birthday when you guys called?
I imagine that she did, but I don't remember that.
Okay. Do you recall when she gave me store stuff?
Yes.
And when we were talking about that, did I write everything down and repeat it back?
Don't recall.
Okay. Did I ever agree to any of the proposed contracts from Mom?
No.
Did I express to both of you on the phone that there was an agreement?
No, the first I heard of that, there being a sort of real estate agreement was in, probably February 2021.
Right, and since then, have we discussed on the phone the agreement?
We discussed, I've seen many emails about that.
Mm-hmm. And have I several times said, to Mom, keep your word or be held accountable?
Yes,
And you're aware that I did bring up the agreement in March, and I sent you an email because you were unaware, is that correct?
yes, I received the email, yes, I was made aware of the alleged agreement.
Okay. I think that. Do you recall what I said I didn't want to have happen with the elements when she gave them to me? Do you recall being at the house when Mom was pushing things around and sticking up for me? When she was trying to take things and change things?
Object to the form of the question seems kind of vague.
Does Mom change her mind a lot?
Oh,
Okay. Thanks, I think that's all I have.
Yes, just briefly, I think you testified that in February 21 is the first time you heard of an agreement. I just want to clarify, when you say agreement, are you talking about the agreement that's being alleged by the defendant in this case?
yes,
And so prior to that date, you weren't aware that she was alleging there was any type of agreement?
no,
And then I think she also asked you about her mom keeping her word. I just want to know, with regards to an alleged agreement to purchase the house, are you aware of any instance where Roxanne has not kept her word to Rebecca?
no,
No further questions.
Can I redirect?
No.
Okay.
She's not your witness, and, redirect.
Oh, okay.
Sorry, Karen, you sit down, you did witness community,
Yes.
and then Jean, are you planning on recalling this witness later? Need to know if he's allowed to remain in the courtroom, if you aren't going to call him, or you plan on calling him.
I may need to call him back.
Okay, so we'll be making the exclusion. Or you may, sit down back in the hall. Mr. Warren, you're the witnesses.
No, you aren't. Brett.
All right, Ms. Cheney. Your first witness, will it be you or are you calling him?
Like to talk to him.
Okay. And then there's 33 minutes.
That means I have 33 minutes total. I don't understand what that
30
means.
minutes. For your,
For all of it?
for your portion, not counting cross-examination, that counts for Mr. Gordon's side.
Okay.
Do you solemnly swear or affirm upon the penalty of perjury, the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Please state your name for the record, please. And, have we known each other, how long have we known each other?
Let's make sure that we're picking up on the microphone.
Have you ever known me to be dishonest?
No.
Are you aware of the agreement that the plaintiff and I made in January 29th?
Yes.
And did you watch me complete the consideration?
Objection, Your Honor. Foundation, first of all, he said he's aware of an agreement. We don't know how he knows about any alleged agreement or what specifically he knows.
What's the objection to me asking them what?
It's a foundational objection, so you have to back that and ask him questions about how he knows what he knows.
Okay, how do you know about the agreement that was made between the plaintiff and I?
That called me, told me of the agreement.
Now, let's rewind. Do you remember the first call before the agreement was made, when the plaintiff said that she was selling the house? That Paul was forcing her to sell the house?
Objection, Your Honor. Foundation, I don't think there's any testimony that he was present when such statement was made.
Okay. Can I have exhibit 56, please? Can you show it to me, please? Do you recognize that document?
Yes, I do.
And we've been putting things down on that for what, better part of a year? And what is that document about? Okay, be a little bit more broad. Are we, is that enough foundation to introduce it as evidence?
I'm sorry, I can't tell you until there's an objection.
Okay, then I need to admit.
Your Honor, we would object on foundation purposes, our basis, and also on the fact that this is one of the exhibits that was only very recently provided to us.
The one thing I am confused about is why this affidavit would come in rather than hearsay. You have the witness present to testify, and if he struggles with his memory, you can refresh his recollection by looking at it, but it is the preferred testimony instead of an affidavit for his under oath testimony.
Oh, okay, so he can look at it without me admitting it?
So how that works is called refreshing a recollection. What happens is, if he cannot answer a question, you can ask him if it would refresh his recollection to look at it.
Okay,
Then he can look at it, but he must remove it from his sight before answering.
okay. Okay, so I'm gonna ask you, are you aware of the birthday gift that Mom gave me?
Yeah.
Are you aware of the notes that were taken when the birthday gift was given?
Yes, ma'am.
And what happened after the gift was given? What did she do?
Objection, our foundation, we don't know how he knows about the birthday gift or the notes that were taken. We don't know what the birthday gift was.
Christian, are you with me all the time, and are we constantly in communication over the phone, text?
Yeah.
Is there much that happens in my life that you don't know?
No.
We're running short on time, so do you have any doubt that there was an agreement to buy the house from Mom, transferred through the trust.
Objection, Your Honor, foundation.
Are you aware of the agreement that my mother and I made?
Yes, I am aware of.
And as part of that agreement, did she roll her debt into the house price?
Objection, foundation.
The reason why we're running into this foundational issue, is we don't know how to do it. Just the fact that it's in your community is not how you specifically are thinking about this agreement. So if you're looking to resolve the foundational objection, that's where you should focus.
Understand it, women.
We don't know how, thinking about the agreement, and I'm also cautioning you to make sure you're including approximate dates so that we all have an understanding of time involved.
So in January, the agreement was made, correct?
We had a year,
2020, January 29th, 2020, is that accurate?
That is accurate.
And between January 29th and February 17th, or whatever day they got married, did I plan their wedding as part of that agreement?
Absolutely.
And did I move all of the, pass everything to the plaintiff at her request?
You did everything she requested.
And during the remodel, was all of that done at her direction?
Yes, it was.
Is there any question that I was getting paid for my work?
Objection, Your Honor, foundation. We don't know how we would know if there was any question.
Christian, were you involved in the remodel?
I was.
And were you one of the trades that I was allowed to subcontract?
Yes.
And did we actually have a credit card number in hand the day that she called to say that she was selling the house?
Objection for relevance and leading, Your Honor, also.
Were we contracted to do a custom wood floor?
We had extensively talked about it
And were you to order what, the floor? Did you have the credit card number to order the wood for the floor?
I did.
And why did you not order the floor?
Objection, Your Honor, leading.
I can't ask why he didn't, okay. What stopped you from ordering the floor?
I stand objection, Your Honor.
I understand with you that you're being frustrated about it, but you want to help the being rules of evidence or you the objection.
At any point, would I have left the state if we did not make an agreement for the house?
Absolutely.
Objection calls for speculation.
Did I direct you to get my truck fixed so that I could leave immediately?
Yes.
And was that based on her saying that Paul was forcing her to sell the house?
Yes.
Objection, Your Honor, there's been no evidence laid for allegation that Paul was forcing her to sell the house, and there's no foundation for him to testify it.
Actually, we're running into some leading issues here. And so, I'm just cautioning you, again, how you choose to spend the time, a lot of you are to.
I understand. How much time do I have left? What do you think that the court should know about this situation?
It's not fair.
And are you certain there was an agreement?
It was agreed.
And are you certain that she said she would pay her debt in equity?
Objection, leading, Your Honor.
Does the plaintiff keep her word? Has she kept her word to me?
No,
Did she ask you to pay for things that she never, or to pay you back, for her to be paid back things that she never paid you for?
Objection, leading, Your Honor.
Did I ever pay monthly?
Objection, foundation.
These are pieces of testimony that are presented by the mission.
Okay. I guess I have no further question, or I want to get that affidavit in now.
Here's some problem with it. Even the court offers.
Okay. Christian, is there anything you can think of that I haven't asked you?
Objection, Your Honor.
That you'd like to share?
you know,
Was the remodel to be fully paid? And were you present during countless hours of consulting about things?
yes,
What was the budget for the remodel?
I believe it was about 40,000,
And that was when we started, correct?
correct?
And did you watch me did you see all the work that I've done?
Yes, I know,
And that was all to be paid, correct?
correct.
Have I been paid?
A small amount,
Okay. And how was I to be paid for the rest of it?
I believe it was in equity.
Thank you, I have nothing further.
I believe you testified earlier that what you knew about this alleged agreement came from your conversations with the defendant, is that right?
Correct.
You mentioned there was a remodel done. Is this a remodel that you're alleging was done on the house at issue in this case?
Yes,
Do you know if the defendant ever provided my client with an invoice that broke down the amount she's claiming she's owed?
I believe they worked on something, but I've never really saw a document of a total breakdown.
And would it be fair to say that you've never seen any type of signed written agreement for Rebecca's purchase of the house from her mother? Would that be fair to say?
Yes,
No further questions.
You can do redirect.
Redirect. Did you hear Mom promise the protection in writing?
yes.
And what was the protection in writing for?
To be put to the trust.
Okay. And do you remember what the price was?
I believe 230,
Okay, and what was that based off of?
February of 2020.
Okay. And why didn't I give Mom an invoice? At what point did she ask for an invoice? Okay. I think that's,
This would just be released.
yeah.
You would, okay, and Mr. Gordon, you would say,
We don't.
all right. So it means Mr. Phillips said, you step down, if you choose to remain in the courtroom, you are allowed to do so. Or free to leave it. All right, your next witness.
Would be me, I guess.
All right, go ahead and stand up and raise your right hand. Okay.
Do you solemnly swear or affirm upon penalty of perjury, the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Gordon, any objection to her testifying from counsel?
No, Your Honor.
All right. You may stay seated there. If you really want to join your witness, you're welcome to.
No, I think.
All right, go ahead.
Well, Your Honor, on January 29th, or actually, I should go back before then. My mom called me and said that Paul was forcing her to sell the house. We were mid-remodel, and Christian he had the credit card because she had just approved the custom wood floor that we were getting in, and I was about to work on the deck. After I had spent about 8 months doing the remodel there, she tells me that Paul's forcing her to sell the house. And so I said, there's no way, not until you pay me, this is, you have to take care of your bill, or I'm going to sue you. And because there's been a lot of issues with my mom, this is something that's been continual, like sometimes she'll keep the word, sometimes she won't. And so after that happened, she called me and she said, I can finally make the past right, so here's what I'm gonna do. And I would like to have exhibit Exhibit 2, please. And Your Honor, these are the notes that I made while she was traveling, because she said, I can finally make the past right, so here's what I'm going to do. And there are a lot of things here. One is,
So it hasn't been admitted as evidence. You can't testify to what it says. Yeah.
okay. Can I admit it into evidence?
You can have Christie admitted as evidence. Mr. Gordon, any objection?
We would object on grounds that it's hearsay.
Your response to that, Ms. Jean.
How can this possibly be hearsay? She said it to me, I wrote it down. These are my notes. As part, there is a hearsay exception, part of my normal process. I'm always writing notes. It's number,
Are you trying to say the business record exception?
or present, then state of mind, or present tense. I have neurological issues, I'm sorry.
Take your, I mean, I don't, I know that there's a time issue, but.
Yes. It is, I have a sense of impression.
Mr. Gordon, would you like to respond?
I don't know if she's laid the foundation for that, so we maintain our objection.
You withdraw your objection regarding hearsay?
No, I think it's still hearsay.
So I'm going to overrule the objection as the foundation, and I'd like you to respond to the hearsay exception argument.
Well, I think if she's going to argue it's present sense impression, I think she specifically needs to lay the foundation as to, date, time, and manner at which these notes were taken down.
These notes were taken down on January 29th, 2020, as the call records reflect. when she called me up and said that she can finally make the pass right, so here's what she's gonna do. That ample foundation?
I've already said that I'm overruling your objection on the basis of your argument regarding hearsay.
regards to yours, I'll concede, I think that's probably enough to get it into them.
Right, so exhibit 2 is an objection.
Okay, this is the original writing that I made of our agreement when she was traveling. These were all the terms that I had to do, all of which I fulfilled. She was, in 2018, I did a remodel on her entire house in West Phoenix. And this was blessed by both her and my stepfather. And in addition to that, I also got his VA back pay. Now, the reason I moved up to Cottonwood was based on Mom coming and giving me my first half of the first back pay check. So she asked me to come up north and do the remodel for her. At first it was every weekend, and then it turned into full time. Now, when she went to get married and said she was going to sell the house, I was like, no, you have to pay your bills first, or I'm going to sue you. And I will warn Paul of your character. And so she called back, and this was the proposed agreement that she made, which was market February 2020. And in return for putting the house through the trust, she wanted the boys on board, a seamless transition to her new life. And she actually brought up her past debt and wanting to settle it. One part of that was a building in Michigan that I was entitled to half of. Another part of that was a $49,000 insurance claim that she kept years ago. And I was never discharged on her bankruptcy, and she has constantly promised to do something about it. And so finally, now that she was moving on with her life, this was her suggestion. All I did was write it down and agree to it, and then perform every single aspect that was required of me. And then she turned around and said that June 13th was really the first time that I realized she was going to try and pull things out. But then I started writing that draft to her and had some conversations with my brother and some other people. And then I got the second email, which really had key pieces of the agreement, like talking about how it would, just kind of reflecting like she was going on that. And the reason for me not being very assertive with my mother about the fact that there was an agreement was because she would do bits and pieces and act like she was going to honor it, and then it would be a back and forth. So that's basically what.
Ms. Shee, are you finished?
Yes, I'm sorry. Oh, did I admit it into evidence?
It is admitted.
Okay, great. What else is important? Can I have exhibit number 6, please? I was talking about different things that she had me do, and she was saying that she didn't. So this says, oh, that looks nice. I can't wait to touch it. Is 2 timers, is that enough?
Hold on. We're testifying from the exhibit. So what generally is the exhibit? When was the exhibit?
This is an exhibit that goes from August 2018 to some places, I think, all the way up to like 2020 or 2019. And it's about the scope of, things she said she didn't hire me to do. Or now since.
Are you asking for statistics to be admitted?
Yes, please.
Mr. Gordon?
I'd accept on the basis of the foundation and also relevant, I'm not sure what the extent this is going back to 2018 and talking about amounts owed. I'm not sure how that's relevant to the issue of FICA possession.
I'm going to allow exhibit 6 over objection.
Yes, this is, these are just a few. There's actually like a whole year of back and forth, and the reason that it goes back so far is because this is from the beginning. She submitted some things about how she's paid an invoice. Well, she only paid me for things not really related to it, and that was just reimbursement for materials. I haven't been paid for it because she wrapped it into the house. And then when she asked for an invoice, it was when she had started trying to pull the money that she already paid with the house out of it, because the house went up like a bunch of money because of the pandemic. So she no longer wanted February market, 2020, she wanted more. And at the back of this exhibit, it confirms what Christian testified to, which is this is starting, and this is in 2019 when she was talking about $40,000. After that, it went up to 60, and we're talking like the kitchen, brand new floors. I did, can I have exhibit 10 through 12, unless you have any questions for me, Judge? I'm sorry. And she says, would you encourage Christian to please get me a cost for, I think he said White Oak. I want to do it the best that can be done. Maybe he can get me a cost on what he thinks that would look like. I mentioned I didn't really want to spend a lot of money, and although that's true, I'm thinking now it would be nice to do something that really increased the value. So it's basically talking about all of that. Now, I think that that's it for this one. Thank you. I don't. And there's nobody to tell us what I just said either. Oh, I guess that I'll go with exhibit 55.
Just letting you know where you're at, 206 minutes, you may want to take some time to.
Okay, we talked about I talked about the birthday call earlier, and that's what this exhibit is about, and I'd like to have it entered because it was memorialized the same way as the agreement that we made.
Section hearsay and foundation, Your Honor. And it's one of the ones that wasn't disclosed earlier.
Section 16.
Okay. I'm not going to argue with it. Foundation, how do I? Oh, exhibits 10 through 12, please. That's number 12. There should be 10 through 12. There should be a big fat stack. Wait a minute, something happened. That's only, Oh, are there multiple pages in each one of them? Yes, this is,
Your photographs?
yeah.
Yes, I've got
Thank you. These are pictures of the work that I did at the house that she contracted me to do. And in the email earlier, that's what she was talking about, was the work that has been done. So I would like to admit these into evidence for you, Judge, to see the work that was actually done in the house. And I mean, we're talking a complete remodel, heated floors. And I know that I'm running out of time, so I think I probably have to end there, huh? I mean, it was,
Mr. Gordon, do you object to the addition of 10, 11, 12?
no objection.
10, 11, and 12 are admitted without objection.
Your Honor, do you look at these? These are for you to look at, right?
So what I've been doing is as exhibits have been pictures, when you're finished with them, we've been taking them, so I can look at them.
Excellent. So that would be the work that I did.
So, Ms. Cheney, do you want us to save your remaining 3 minutes for redirect after
Yes,
comment?
yes, please.
Okay. Mr. Gordon.
Thank you, Your Honor. Just really quickly with, Exhibit 2, the notes that you took, if you could look at that. Is there anything on there that tells us the date those notes were taken? Is there a date written down there anywhere?
No, but the Bath and Body Works receipt has a date on it, as you can see.
And you'd agree you don't have any type of written contract with your mother, correct?
Yes, I would agree that there is no written contract with her.
I believe your testimony was that this alleged agreement you're claiming was also supposed to give you credit for a portion you're claiming of Al's back pay of a building in Michigan. I believe you said about $49,000 on an insurance claim. Is that correct?
Well, that requires a little bit longer of an answer there.
Well, generally speaking, that's
Oh,
the answer.
sorry, Ms. Cheney, you have to make sure that you have the phone in front of you, and it's hard if you're looking at Mr. Gordon, you can make. I'm sorry. Oh, see, the microphone is off right now?
Not anymore.
Okay, thank you.
Okay, and I'll see if I can maybe phrase it a different way. Is it your testimony that there were to be some type of credits you would receive towards the purchase of the house based on old debts that you claim your mother owed you?
There were several aspects that were to be deducted, and that was one of them, yes.
Okay, can you show me on Exhibit 2 where it gives specific dollar figures of the
Oh,
credits you were supposed to
It
get?
doesn't give specific dollar figures on Exhibit 2.
I'll have you look at Exhibit 8.
Yes.
Sorry, I'm using my old name.
This is my exhibit.
Exhibit 20, please.
Like, yeah, look, those are bills that I paid.
Exhibit 20 has already been admitted at our last.
Oh, this, yes. Carry on.
Thank you, and I'll have you turn to page 4,
Mm-hmm.
that exhibit, which is very good. Do you have that in front of you?
Mm-hmm.
This is an email dated June 13th, 2020. Did you see that?
Uh-huh.
Okay, this is an email that your mom sent to you and her husband, correct?
Correct.
Okay. Now, I'll read the second paragraph. Well, actually, I'll read both. I've been thinking about what to do with the house. I'd really like to work with you to make this work. I also want to be fair with the inheritance. What can we do? Here's part of what I'm thinking now as a starting point only. It is not a legal agreement that we have consulted about, but thoughts to consult about my proposal. Do you see where that's in that email?
Yes, I see that.
Now, your claim is that you actually had an agreement with your mom that
Correct.
dated back to